All right, welcome back. Hey, you know what? I just want to knit together a couple different concepts here. Remember, we just got off the phone with Dan Eldridge, who is working on that unconstitutional gun ban law that prevents legal gun owners from getting a gun. And then you just heard the story of Andrea, whose son was shot by a gun owner who had an illegal weapon, an illegal silencer, an illegal extended magazine, an illegal switch that turned it into an auto. And that guy's out on bail. Like, not with no bail. He's just on electronic monitoring. He shoots a kid. Attempted murder charges is going to be upgraded here. I mean, he's got 2 Class X felonies against him, and they're going after the legal gun owners instead of going after the bad actors. It's the same thing in Chicago. This is happening everywhere. They have a proclivity to protect the perpetrators instead of the victims in this state. That's the type of state that Governor Pritzker has set up. He cares more about them than the actual victims, more about the criminals than the actual victims. Oh, my gosh. Okay, but, you know, here to talk about more about this, because there's a lot to discuss here, is Kevin Coyne, a friend of mine, former Naperville City Council member and the founder of Safe Suburbs. Kevin, thanks so much for calling in and being on my show.
Hey, thank you so much for having me.
Yeah, so we just fully discussed Andrea's case, and she flat out said that the reason that the guy was let go is because of the Safety Act.
Yes, and her case is not isolated. There's been numerous cases very similar to hers, in some cases even worse, wherein you have these terribly violent offenders who are released after being charged with very serious crimes, despite the fact that many of them have horrendously long records, clearly dangerous to our communities, getting released pre-trial, and it's complete insanity. And unfortunately, Naperville's been very blessed, very safe from crime by and large, and so this incident, I think, gets more attention than others would. But I mean, it's not isolated. There's cases like that all over the suburbs.
Yeah, but you say that it gets attention, but honestly, until you told me about this case, I had never heard about it. It seems like there's almost a media blackout on this particular case.
Yeah, I mean, and I do appreciate you covering it, and there's some truth to that, no doubt. I mean, but at least your show is covering it. I mean, think what happens in Cook County and Chicago area, where you have case after case after case like this, where you have minors being shot, young people being shot, and victims of crime, and those doing it get promptly released, and there's zero attention on it. And I agree with you. I think this Naperville case should be front page news. Of why it isn't, I don't know, but I really thank you for at least taking it up.
Yeah, well, I mean, I'm happy to do it. When the Safety Act passed in 2021, it's almost 4 years, and we're still dealing with fallout from the Safety Act. It's not a really good system, and if I remember correctly, like you can be held if it has to do with domestic violence or drugs, but you're not necessarily going to be held in detention, pretrial detention, if you've got a Class X felony for attempted murder. Does that make sense?
Yeah, it doesn't make any sense. And I would say this, that when it first came along, judges by and large were very conservative in letting people out, pretrial. That seems to be changing a little bit. This case, which we just heard about tonight with Andrea's son, that, again, is not isolated. There's been multiple West Suburban cases wherein violent offenders who have done similar, if not worse, crimes than what we heard about before I was on, those involved were let out pre-trial because of judicial discretion. And and that was the fear, right? I mean, with the Safety Act originally, if the judges are going to keep everybody in, well, it's almost a net neutral. But what we're starting to see is that judges, through their discretion, are not holding them. And you're seeing very violent people are being released without anything but electronic monitoring, which, anybody that follows this stuff knows is a complete joke. I mean, there's been numerous cases of people committing terrible crime while on electronic monitoring. I don't think that's a safeguard for the communities at all. And I don't blame, unfortunately, the poor mother who's gone through this terrible circumstance for being alarmed, that the shooter is on electric monitoring. That's not any safety for her family.
No, not at all. I mean, I'd be worried the entire time. That's just crazy. Okay, So another facet of this, and you have to wonder, it appears, though, at some point that the judges were detaining a fair amount of folks. And so what started to happen is criminal defendants and their lawyers started to just automatically appeal to be released. Mm-hmm. And this ended up in, clogging up the appellate court. This is an article written by Jonathan Bielek in the Cook County Record dated November 13th, 2024. So just this week, he wrote, Illinois state officials say reforms put in place earlier have significantly eased the crushing burden that had buried state appeals courts under an avalanche of appeals from accused criminals seeking to use a controversial Illinois law that eliminated cash bail to challenge judges' orders keeping them in jail while they await trial. So they get detained actually by the judge, and then their lawyer and them can appeal to the appellate court and say, no, we really shouldn't be detained. I mean, the Safety Act says that you got to let us go. So they've got all these appeals taking place. And at one point it said, according to an information table presented by the court, the number of appeals challenging pretrial detention orders numbered 1,041 from January 1st to April 12th of 2024. So just about 3 months, 1,000 pretrial detention cases. And now, because they've made some reforms to the appellate process there, those appeals have dropped to 154. However, one more stat here. Prior to the Safety Act, state appeals court had handled 171 such pretrial detention appeals in the previous 10 years. So they're using the system, they're using the Safety Act to try and get out of jail.
Well, yeah, and that's the other part of the Safety Act. It's not just the serious public safety issues that have been raised and continue to, I think, worsen. It's been the cost of managing this, wherein you have now virtually every kind of case in which somebody violent is charged with a crime and held. Now you have to deal with the appellate process, and it's created a huge burden on our court system, on public and state's attorneys' offices, public defenders and state's attorneys' offices. There's been a huge cost element to this that I don't think has gotten, near the attention that it should. We all know about the state of, by and large, much of Illinois' fiscal condition. It's been worsened because of this.
Well, I mean, I talked about this probably a couple months ago when I got word of it from Cook County Commissioner Sean Morrison. But also, I've had Patrick Keneally, state's attorney in McHenry County. He called the Safety Act an abject failure and faulted the law for leading to a 280% increase in failures to appear in court. Additionally, Circuit Court Clerk Iris Martinez, this is Cook County, notably stated in a letter to Cook County Chief Judge Evans that as many as 3/4 of all criminal defendants in Cook County may have failed to appear for required court hearings in the 12 months that followed the effective date of the cashless bail law. That's the Safety Act. Martinez said her office logged more than 67,000 failures to appear during that time, which she said placed a heavy burden on her office and the courts overall. I mean, there's something wrong here.
Yeah, totally. And the other aspect of this, which the Safety Act was not prepared to consider and has been, public safety concerns have been exacerbated by, is the migrant infiltration, wherein you have folks who are being released and there's no ID, there's no address, there's no record, you don't even know who they are. They get arrested, charged, and then promptly released. They're never coming back to court. No one even really knows who they are. There's no way to find out. And so, the Safety Act, in that case and many others, has just proven to be a complete disaster for public safety. And I really hope at some point it gets reconsidered.
Well, personally, I can't wait until Tom Homan comes face-to-face with Pritzker and the Safety Act, both in conjunction, and we'll see who wins that fight. My money's on Tom Homan.
Oh, I agree, and I hope he gets after it, and I hope we see change.
Yep. Okay, he's Kevin Coyne, a former Naperville City Council member, lawyer, and a founding member of the Safe Suburbs USA. Thanks a lot, Kevin, so much for joining me on this Sunday night.
Jeannie.
You bet. Have a good night. We'll be right back with the Edgar County Watchdog.